Sunday, March the 4th. Welcome to landlordsjournal.com.
2012.
March 4th, 2012. It's the end of the year coming sometime this year. I'm not quite sure when. But for now, we are talking at landlordsjournal.com. And today's topic is perspectives on leases. On the agreement itself, we're going to be talking about the lease agreement and different perspectives about the concept of leasing property itself. We wanted to talk about the tenant's perspective and the landlord's perspective and pros and cons of even having a lease. We're going to challenge some myths and just examine some things, I guess, in this topic. So, who wants to say something about? Why don't we start out with the perspective of the tenant? As far as a tenant goes, should a tenant want to sign a lease?
A lease is really good for tenants because it protects them from, being given 30 days notice. I mean, a landlord, contrary to popular belief, from what I've found anyway, you don't have to have a reason to remove a person from your property, as long as you're not breaking any federal laws or local laws. You can't say, oh, you're Muslim, so I don't want you living on my property. As long as you're not breaking any laws, I mean, you can give them 30 days and ask them to leave. A lease, from a tenant's perspective, helps them. At least they know that they have that duration, that their tenure at that property is going to be for at least a year, 2 years, or whatever it is.
In case the property's sold.
And then a lease, in case the property's sold again,
the lease follows.
Typically, the lease follows the
unless there's express language in the lease.
Unless it's expressly written in the lease that's not the case. But like in that case, if it's sold, like you said. So, especially for a tenant, and a lot of people I've heard say that it even protects tenants more than it does landlords. I need to revisit this and do some more, because we haven't really spoken about leases a lot. It's been a while since we've visited that topic, but I've heard that some landlords don't even like to use the term lease. They use rental contract. And I was looking up on here to find out what the difference was. They don't like to use that terminology, but I think it's really good for. I mean, we would never, like, we're getting ready to, from an investor point of view, we're on the other side of it commercially as a group, and we would never sign with a commercial landlord a lease that we would never sign. We would never just do like a handshake and hope for the best.
A rental.
Right? Enter into a rental with a verbal contract, which there is, there's a legal basis for oral contracts, but that's, anything that's not in writing is subject to. But I think it's real important. It's real important for tenants and landlords, but I think especially for tenants.
Oh, I totally agree. I think that's who gets the most protection. There are some exceptions to that. If you have very explicit terms in your lease that there are performance issues, that you must do this or this consequence. But one thing that does is remove ambiguity, which usually benefits the tenant, because it's usually the tenant that has the misunderstanding about the expectations. But I think in general, a lease is better for a tenant than it is even a landlord. And it's funny that the tenants don't bring the leases. A tenant doesn't bring the lease. I've never heard of such a thing.
We've never had anyone amend our lease and say, "Hey, we want this taken out. We want this taken out. We want this taken out," because we're on the end of signing a lease. We're on the tenant side now in a commercial building. And we're like, we want this changed, we want that changed, we want this changed, we don't like this, we don't like this. Hey, you need to call our attorney about that, that kind of thing. And so it's we're on that end, and we never had anyone say that to us. We've never had anyone want to make any changes or or negotiate a lease like we're doing ourselves. So But it's anything that's written down is I mean you can fight it in court, and it makes everyone's position very clear. It's a contract.
And I think it helps eliminate that. Sometimes people expect certain things, and when it's spelled out, it reduces the need to go to court. You go to court when you don't. Well, I thought I was going to do this, or he said this, or he said whatever.
That's very
and when it's written down, there's a dispute. Whoever has the misunderstanding, it could be both, but whoever has a misunderstanding says, "Hey, you said you would do this, and you've not done that."
It's kind of like preventive maintenance. It's, like when you go into a garage, a public garage, is we are not responsible for lost or stolen items. That basically saying you can't sue us if your car's broken into or whatever.
Right.
But really you can. There's nothing to preclude you from going to court and saying, hey, you're responsible for this, or hey, we want you to pay for this because it's in your garage or whatever. There's nothing to stop you from doing that. Now, whether you win or not, it's another story.
Right.
But there's nothing to stop you from doing that. So it's kind of like a preventive maintenance for that little sign. And that's what a lease does. It's preventive maintenance for a protection between you and the tenant or the rental contract. It says, hey, this is what we expect. That if you don't do this, we're doing this, and it's all in black and white, and it's all very clear. So if you have to go to court, if you have to go, if you have to go to court because there's a dispute, it's all very clear. It's written down, and they've signed it, and it's in black and white, and you can't argue that.
And it's a good lease is a good fence, and good fences make good neighbors.
Exactly.
It spells out, this is your side and this is my side.
Let me ask this question. Going back to the no lease versus rental contract, what about those people who don't pay their rent and you want to evict them but you can't do it in a timely manner? Does a true lease prevent you from doing that?
No. They're in breach of, if that's a breach of contract when you're not fulfilling your obligation, then they're in breach of contract if they don't pay. But that's the case whether you have a lease or not.
But you couldn't remove them from the property any easier or quicker whether you have a lease or not.
You still have to go through
You still have to go the same channels.
You still have to go through the legal process for eviction, which can be cumbersome. But
Can be.
I think for the most part, it's in our experience where we are. The cumbersome part is the time between when they don't perform. When you don't pay the rent,
you're hoping
exactly. All that effort goes into, hey, when are you going to pay? What are you going to do? What are you going to do?
Right.
That's where all the effort is. And then when you finally get to the point where you say, okay, this is it. I'm filing. From the file to the eviction has been the least cumbersome portion of our experience on that. It's a lot of work to talk to people and listen to them, and because there's always a story, and sometimes they're legitimate, and sometimes there's not, and a lot of times there'll be a non-safety issue that somebody says, well, I'm not paying because that trim work is loose. Okay, well, that's not a safety or performance issue. You still have to pay your rent, and if the place is not up to the standard that it's supposed to be, then the opposite is true, and the tenant has the right to say, hey, you're not performing. I want to exit this lease, because that's all an eviction is usually. It's an exit. It's a way to get out of the lease. The obligation that you will allow them to live in this for this term, this period of time, and so what the opposite. And a lot of people think, well, I'm not going to pay the rent until they do this, and I'm not going to do this. And don't get me wrong, there are. I have personally seen instances where a landlord had a performance issue where they did not take care of, and even though technically you're still supposed to pay your rent, and you're out on a contract when the landlord doesn't do what they're supposed to do, you're out on that is to move. That really is. That's basically, unless you have specific terms that say, I will relocate you, or if this doesn't take place, that's their out. But I have seen recently a landlord that took a tenant to court and said, hey, they've not paid in X number of months, and the tenant came, and if the tenant came and said, "Hey, you were supposed to do this, you were supposed to do this, you were supposed to do this, and you didn't do it," and so I upheld the rent, and the court upheld that. Now, I think that's shaky legal ground.
But was this locally where we have magistrates that
That's
aren't really,
exactly
that
right.
don't really know? I mean, they're not educated in these matters, so they don't know.
But they're not. They don't have law degrees typically.
They don't have law degrees, so they're not educated in the ins and outs of the legal, these kind of things. And I want to mention this before we lose track. On the LPA.com, it's the Landlords Protection Agency.com, basically. It says, one of their tips is, beware a tenant's lease agreement. And again, this is not commercial. But it says, some tenants come with their own lease agreement already prepared for you by their attorney in many cases. Watch out. First of all, I have never had good experiences with tenants who are experts on landlord-tenant law. Assuming, I guess I'm thinking that they're saying that their attorney is not a real estate attorney.
Right.
There's a big difference between a real estate attorney and an attorney. Secondly, it is only logical that the tenant's lease will contain more tenant protection than it will have landlord protection. Mm-hmm. There's usually a good reason the tenant wants to use his own lease agreement. You can bet there are lots of innocent-seeming little clauses in there that wouldn't even raise an eyebrow, but can cost the landlord plenty. Just stick with the landlord lease. So,
I
agree.
I would definitely not agree. I think that you need to be receptive to amending the terms.
Yeah.
If there is a particular need. I totally agree with that. It needs to be a two-way document.
Yeah.
However, I would never agree to
on
just wholesale remove our lease and put someone else's in it.
Well, that's cost prohibitive because our leases are vetted already. We have a standard lease that the language has been, this is our language, this is what we like for our properties. And if you had to do that for every Tom, Dick, and Harry that wants to bring you their own document, you'd have to get looked at
that's
by
a
lawyer.
that's a good point.
Yeah, you're talking about having stuff, if you're doing your due diligence, I mean, that's a big time and money waster. That's kind of foolish.
I bet that's a pretty, that's a foreign to me. I've never heard of any.
I haven't either until he mentioned it. I mean, I could see somebody doing that.
I could if you were
not
in a
around
particular
here necessarily.
a particular circumstance where there was a
Highly
high
desirable.
rent. Yeah, exactly. High dollars. That's
High,
what that's
New
what
York
that sounds
City
like.
or Manhattan or something. I could see that.
I just want to, this is really good. He has some tips for landlords, but I know this is kind of off topic, but this kind of goes with our whole MO here. It's, as a group. It says, don't flash your riches in your tenant's face.
Mm-hmm.
If you have a beautiful car that you are proud to be seen in, try not to rub it in the faces of your tenants. Tenants resent that a landlord who arrives in a Mercedes to collect the hard-earned rent that the tenants just scraped together. Do you think they'll feel bad for you if you're forced to pay late or if you're behind on your mortgage? I had to mention that. So I know it's off topic. But
No, we've known that years ago. We
I know.
had deal mobiles that only have two hubcaps and 4 cars. I think when didn't we drive around with your
That was a
station,
good car.
your station wagon? We drove around the whole station wagon for a while making deals.
Yeah.
That worked. We're just barely scraping
some
by,
really
ma'am. I'm so
Deal
sorry.
mobile.
So,
Okay, so back to the leases.
so at least provides tenants a lot of protection when it comes to what you have to. It spells out a process. If the landlord is displeased, it protects the tenant. There's some.
It's mostly about time for the tenant. It's mostly about time. I won't let you move your family in this house and go through all this effort, and 30 days from now tell you, as long as you're doing what you're supposed to do, and tell you that you've got to move again. That's the number one protection that a lease offers a tenant.
As long as they meet their requirements,
As long as they meet those
lease,
requirements.
they can stay there for the term of the lease.
What happens, and this probably doesn't happen very often, but what if the owner experiences bankruptcy and has to settle and get rid of the building? How does a lease...
That's a very common thing, and it's
Especially
interesting. It's
now.
been coming up. I've
what
heard some
happens?
coverage in national
Thought of that.
news
Quite
broadcasts.
frankly, in that circumstance is different. Bankruptcy or a foreclosure is different. There are often protections for sales,
Mm-hmm.
and we're hearing a lot of people over the last 3 to 4 years that have had to move out of their places
We've
because
heard that
of
locally.
I mean, it's happened a lot.
But I was wondering how that pertains to the lease. Like,
I don't have a good answer for that when it's a foreclosure. I'm assuming that I would assume that legally that
like if a bank takes over that,
the person doesn't have the ability to keep that lease. That lease
it's
is
null
not.
and void.
I would think
so
that
you're done.
yeah, and I don't know the answer. I can't legally say that.
They give you 30 days to vacate, probably, and the bank's going to sell the
I've
property.
seen that happen so
I think that's
much.
what
I don't
happens.
think that it's. I think that that's what's happening.
Yeah.
I don't think that it's the same as a sale.
Yeah.
As a regular sale, a voluntary sale.
Yeah, foreclosure. I bet it nulls and voids the lease.
That's a good question, and we can find out to answer that and give you a
Back
little
to you.
tidbit at the end. We'll tack that on in.
And what is that?
If there's a foreclosure, is
Against the owner.
is there foreclosure against the owner? Is the contract or lease is it
Is
if
the
you have
tenant protected?
yeah, I wouldn't think so.
I
For
wouldn't think so
example,
either.
I could have a 60-year lease.
Mhm.
If I knew I was going to be, losing a place and I had a tenant in there, I could sign
That's
it.
actually a valid point.
Or even a
There's
lease
actually
option.
called
I mean,
there's
it gives you
actually
more skin
called
in the game.
a life estate that will enable, say for example, the previous owner. And this is where things can get very complex. There's actually a lease. We need to be careful about this when we purchase a place. That's why it pays to have a good real estate attorney.
Mm-hmm.
There's actually a document called a life estate that say I could implement it on you. Say I owned this house and I wanted you to have it. You're a family member, blah 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 blah, and I entered into you a life estate lease where you were able to live in this house at a set rate of rent
As long as you live.
as long as you live.
wanted it.
And I'm thinking, and it may or may not be able to go to your heirs. I'm not sure how that
It is
works.
not.
I
That's the
don't- I think
nature.
it's not.
It's definitely not. I've had experience in that
You think,
particular.
you've had experience with
I've
that.
had personal experience in that.
Okay, but so it's a life estate, and it does not follow your it doesn't go to your heirs. But what it does is it puts a stronghold on that property. So if you have
Sometimes it does. You can still transfer the property, but that's just like any other lease. That transfers with.
but someone can go, hey, I have this lifelong lease, and I'm at $500 a month, and hey,
And it depends on what the terms are. For example, the
Right.
terms on the life estate that I've had experience with, it was a property where there was a life estate for a person to be able to do something. And in this particular case, it was to seat a mobile home on a piece of property. And the property was purchased. The person never had any intentions of putting anything on it. It was expressly put into the agreement that it was for her personal use, and she elected not to do that. And what she didn't want to do, she wanted to extort the cost. She wanted to charge. She wanted to sue for $5,000 to get. She estimated how long she was going to live, and she put a price on it and said, "Hey, you bought this, and it's got this life estate, which specifically says this, and I think I'm going to live till I'm 90 years old, and I want $200 a month till I'm 90 years old, and I want all that up front right now." And that fell through. It's not. They didn't have a leg to stand on, but. It's
a valid point. And if you have someone pushy enough, and they have their paperwork in order, and they knew what they were doing, I mean, it could be a big problem.
But I guarantee that doesn't follow foreclosure, because then, I mean, I could go and sign a lease. You're going to foreclose on me tomorrow. I sign a lease with you for the next 40 years. I can sign a 40-year lease with you that says you can have it for $1 a month.
But that agreement is with two people, and if you foreclose, that takes one party out of the agreement.
But a lot of
and
times
I
it doesn't.
steps
It's
in.
not a permanent thing, but it creates enough paperwork and enough doubt that you can stay in there long enough. There was a case on on the television not that long ago, where a guy knew how to work the system, and they were foreclosing on him, and he found some kind of something that he did, and he's able to stay in his house longer than the normal person, maybe 3 or 4 years. They eventually got him out, but he basically did not pay his mortgage for a long amount of time while it was wrapped up in all these legal processes. So a lot of times it's not whether you're going to win or not.
At the end.
In the end, it's a matter of just tying it up in these legal matters and making it complicated and very expensive until one person gives in and say, hey, okay, just go ahead, we'll do what you want us to do. It just buys you more time in a lot of cases. It's not whether you win or lose, it's tying it up in court. And people are not, no one's going to educate you on that. No one's going to say, oh yeah, you could do this and do that to tie this place up and blah, 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 blah. It's just a matter of, like Donnie said earlier, kind of pushing the limits on what you can do. But, I mean, landlords, of course, are not going to sign a lease like that with anyone. But leases, when there is a dispute with a tenant, when you say, hey, this person tore this place up, this person, did whatever, he didn't follow through on his contract, the first thing that happens when you go to court is, where's your lease? What did it say in the lease? If you don't have a written document when you're trying to take someone to court or trying to, take someone to get someone out, it just makes it much more difficult. They could say, well, he told me I could stay here till July or August. He could be lying through his teeth. If you have a lease that specifically says, hey, you're supposed to be out of here, you didn't pay, you didn't fulfill the terms of your lease, whatever, then it's all in black and white. If it's not in your lease, it doesn't exist.
Well, and that brings up a good point about whether or not, when things are ambiguous in a lease, if you have something that you want somebody to do, some kind of performance, whether it be to pay, mow the lawn, whatever it is, you need to have very explicit terms on what those are. Because if the term is ambiguous, then as the writer of the lease, you have the higher standard. If you wrote out a lease that says you must do this, then if it's ambiguous, the law favors the person that did not write it. So if you want somebody to leave your carpet in good shape, then one lease that I'm familiar with, and someone stipulated, it must be professionally cleaned. You can't come in and say, oh, I cleaned the carpet. Oh, it's not, doesn't look clean to me. Well, it was cleaned because I did it. Well, that's not good enough. In this person's lease, they've had enough experience that they say it must be professionally cleaned, when you must bring me a receipt for that, or you pay us at the end. But
That's
the
a
carpet,
third party.
the carpet must be cleaned by a third-party professional on every instance. It doesn't say something vague like that must be kept in good order. Good order is very vague, and what does that mean? My good order is different than yours, and especially as a landowner and the person that wants to turn around and rent it, you might say, well, nobody's going to rent this till I get this cleaned.
And kind of puts it on a third person, and people are like, why would it have to be professionally done? That sounds awful.
Crossing your
pretentious or whatever.
It eliminates
because
ambiguity.
It eliminates ambiguity, just like he said. That's why it needs to be professional.
How often you mow your lawn.
By a
If you put in there,
third
will upkeep the lawn, they might do it once, but that might fulfill the language of the lease.
Good point.
Right.
If they need to mow at least once per week,
Exactly, once a week, once every 2 weeks, whatever, because you could have weeds, up to your eyebrows, and they say, well, I mowed it 2-3 months ago. What's your problem?
It just grew like weeds in the last 10 days.
I'll probably mow it again in a month or two, and they're okay with that. You can't say anything, even though the city's in your statements that says, what are you doing?
Well, we have about 3 minutes left, and Donnie hasn't really said a word, and he has some experience on a lease that he'd had with.
I had a. I can say I had a lease agreement with a relative that I had to. I leased some property to a relative, and I myself am glad that I had the relative needed a place to live. It was rather under duress, sort of, and I didn't know how reliable. I didn't want to get into like an exploitive situation that would create resentment with a relative. So I had a lease. I drew up a lease, and ultimately the same. Ultimately, I did have. He wasn't able to keep up with the terms of the lease, and I was glad I had one that instead of it being kind of make up how we're going to have this relationship as we go, sort of thing, that we had something that we had both agreed to, that
You agreed. If you didn't pay the rent, you would move out.
Just like with everyone else, I had a formal agreement, and
that made it easier to end
yes.
the business relationship.
Right. It made it easier to.
So he had to acknowledge that there was a deficiency on his end.
Right, and I had asked a lawyer before I had to move in, and he said definitely have him sign a lease for this very reason, because it was kind of a situation where they were moving in under duress, financial duress, and that.
I'm loving it.
So I for one am glad that I had a lease for that situation.
And every situation is different.
That's the key. And I think that's where that's the takeaway from this is there are times for both parties that leases are very important and are less important, and you have to evaluate your particular circumstance. I think that a well spelled out lease, if it's got a lot of terms in it, and you take the other side into account and you allow them to have input, I think in that circumstance that's the perfect storm, and that's a good thing for both parties. If you've got everything spelled out explicitly so that everybody understands what they need to do, it makes it a lot easier.
Just like
in general,
employee-employer contract. I mean, it's the same way. If you have a job, it helps.
All right. Well, America, I'm glad you spent 20-25 minutes with us.
Nicaragua too. Shout out.
And shout out to Nicaragua. Well, America, take care. Thanks for joining us on landlordsjournal.com, and we will be talking with you more later. Okay, bye-bye.
Bye.